Excellent. So thank you everyone for joining us. And it's my very great pleasure and indeed my privilege today to introduce Professor Jacob Sherkow. So Jake is currently Professor of Law at the University of Illinois College of Law. He has previously been a prestigious visiting fellow at Harvard University, and he's also been Professor at Law at New York Law School's Innovation Center for Law and Technology, which I think makes him the perfect person to speak in our Law and Technology seminar series. So he's probably best known for being probably the world expert on issues to do with intellectual property and the patent disputes around the CRISPR-Cas9 genome editing tool. But he's also written very widely on a number of topics dealing with medicinal products and biotechnologies and their intellectual property relations, including issues to do with the COVID-19 vaccine and cell lines and quite a wide range of things. So I think we're in for a really excellent talk today. Thank you again for coming. And Jake, over to you.
Yeah, Michael, thank you so much for having me and everyone here who's joining today. Thank you so much for taking time out on what must be the end of an otherwise long day to hear me talk about governing human genome editing with using patents of all things. I'm going to share my screen. If you give me 1 second here. Here we go. All right, now I'm going to ask the annoying question. Can you all see my slides? Excellent. So I'm going to speak for about 30 minutes or so, and then I'm happy to field your questions afterwards. So again, like I mentioned earlier, I'm going to be speaking about patents as a tool, one tool for the governance for human genome editing. I think it's just important for me to kind of just start off and just give everyone just kind of some base technical understanding of what genome editing is and how it works. I'm going to briefly talk about patents and licensing, and then we can kind of talk about some of the issues that center with patents and licensing and governance for human genome editing technologies, especially with a focus on some of the democratic concerns, or in some cases, anti-democratic concerns that they otherwise yield. Let's just kind of begin, right? Just, you know, why are we here? Well, 1953, right? Watson and Crick, they discover the molecular structure of DNA. Here's the famous photo of them pointing to the ball and stick model that they otherwise hastily created as an otherwise press tool. One of the interesting things about noting that DNA operated by the kind of the series of nucleotides that we've all become accustomed to, that is the A's, C's, T's, and G's, that make up the genome, is that this yielded insights into how to decode the genome, but really, at least at the time, it was on no one's mind about how to edit it, right? This slowly begins to change. About in the 1980s, we get the recombinant DNA revolution, mainly out of the West Coast of the United States at UCSF and Stanford with Paul Berg and others, right? But recombinant DNA otherwise requires scientists to find genes that exist elsewhere and to splice them with genes that they otherwise want to insert them to. This makes the technology relatively clumsy, or in the software development space, we would say it is not programmable. In other words, you need to build a whole new machine for each additional function that you otherwise want to use. I'm going to pretend like no history had happened between the 1980s and 2012 when we yield CRISPR. There obviously is a lot of history on the development of genome and genome editing technologies until then. But for purposes of this talk, we are going to pretend that full-born out of Athena's brow comes this genome editing technology called CRISPR in 2012. This is first discovered, or I should say, its properties as an engineerable system with minimal components, that being the kind of key determinant here, is first discovered by Jennifer Doudna at University of California at Berkeley. She on the right at the picture that you see here, and Emmanuel Charpentier, then at University of Umeå in Sweden, now a director of one of the Max Planck Institutes. She on the left, as you otherwise see here, found out that this programmable system stemmed from a naturally occurring adaptive immune system in bacteria. As you know, bacteria have a single genome. It is relatively small, or at least relatively small to what we think of as eukaryotic genomes. And so how bacteria developed an adaptable immune system where they were able to recognize and then remember somehow foreign invaders like phages was long a puzzle in molecular biology. This is an interesting way of essentially solving two problems at once. CRISPR mediates, and you'll see a slide in this in about 2 seconds, ways about targeting a precise area on the genome and cleaving it in a precise location. This essentially allows researchers to precisely delete edits of the genome that they otherwise want. In other words, if you wanted to destroy a particular gene's function, this enables one to do that. And then also, with much less precision, add bits of genetic material to the genome within that targeted location. The interesting thing about this technology is that it is otherwise entirely programmable. It uses a generic enzyme, one of the Cas proteins, this is CRISPR associated proteins, one of the Cas proteins, and a nucleic acid that is a mirror of the particular section of the genome which one wants to target. It is otherwise relatively easy to develop these targeted nucleic acids. You can literally order them on the internet direct to your door, and at least here in the United States, roughly 24 to 48 hours. They are cheap, and they can be developed for any particular aspect of the genome within some limits, this being the PAM adjacent spacer motif, right, that you otherwise want to target, right? I can't help myself but mention that despite the fact that Jennifer Doudna and Emmanuel Charpentier got all the glory, a lot of the hard, initial biochemical characterization of the CRISPR system and what in fact were minimal components and what were not minimal components was developed by this man here, Virginijus Šikšnis, him at Vilnius University in Lithuania. He is a biochemist. He worked out the minimal components of this adaptive immune system and found ways to edit the genome that was effectuated through marrying the protein that otherwise was in the Cas complexes to bits of RNA, although admittedly not a single guide RNA that we have come to know and love now. Just simply wanted to mention his contribution here. Importantly, all of this work, both from Virginijus Šikšnis, but then also from Jennifer Doudna and Emmanuel Charpentier, were originally conducted in prokaryotic systems, namely bacteria. But figuring out whether or not this system was either going to work in eukaryotic systems and whether or not one was able to essentially use the system with multiple different guide RNAs at the same time, that is, whether it could be multiplexed, was at least first published by this scientist here, Feng Zhang, of the Broad Institute of MIT and Harvard in Cambridge, Massachusetts, here in the United States. The contention as to whether or not it was obvious to move from the system developed by Doudna and Charpentier in prokaryotic system to the system described by Feng Zhang in a eukaryotic system was a subject of a particularly wide-ranging, still ongoing, and contentious patent dispute here in the United States, which at least during the Q&A period, I would be delighted to answer your questions and chat your ear off about, right? Here's just a simple graphic design of the system that we have here. For those of you who are not otherwise inclined to abstract notions of how CRISPR works, let me describe it graphically to you. The teal blob that you see here is the CRISPR-associated protein here, Cas9. The guide RNA, which I've been mentioning earlier, is the purple ladder-like looking thing here. As you can see, it binds specifically to an area or a complementary area of the genome that is the red or orange uncoiled ladder that you see within the teal blob. And this enables the Cas9 enzyme to make a specific cut, which can then be used in a bunch of different systems, human cells, zebrafish, which is a model organism used in a lot of eukaryotic scientific research, and bacterial cells here, both to remove areas of the genome and also, in some cases, and with less precision, to add it back into the particular construct that one wishes. Suffice it to say that since CRISPR has come out in 2012, there is now a host of applications for it. Just going to mention a couple here, otherwise kind of well developed in the literature, right? We can use these for animal models. We can use these to induce genetic variation in certain cell systems to do scientific research on them. We can use them to fabricate materials. We could use it to edit food. We could use it to develop biofuel. We could use it for therapeutic purposes and also for drug development. I'm going to be speaking today mostly about some of these concerns with respect to human genome editing, but you should know that the technology is otherwise broadly available for a bunch of different applications. Also worth noting that although we love talking about CRISPR, there's actually a bunch of other genome editing technologies, many of which are precise. These include zinc finger nucleases, TALENs, which stands for transcriptor activator like effector nucleases. Go with the acronym, trust me. There are meganucleases, which is a technology that was developed originally in the early 2000s by Duke and a French company called Selectis. They are not programmable, though, and have really never taken off. And then obviously one needs to get all these components physically inside a cell. We call those technologies vectors. And all of this, whether in individual components or in combination, are themselves subject to intellectual property disputes. Some of the uptake turns on what the intellectual property landscape is for these technologies, and importantly for this talk, the way that that intellectual property landscape is governed with respect to who has access over them, right? Brief word about patents for those of you who are not otherwise familiar with intellectual property, right? Patents, what do they protect? They protect inventions, or if you want to use some more of the European Patent Office terminology, an industrial application of an invention. They are not by registration. They need to be applied for. They need to be examined, and they must otherwise meet whatever the particular statutory requirements are in order for them to issue and be legally effective. And significantly, patents are not the right to use any particular invention. Inventors had that right absent applying for a patent or not. There's simply a right to exclude others from using the particular technology. And this must otherwise be done, at least in almost every country around the world, through private lawsuits. That is, the patent holder must go around suing others whom they want to police using the particular technology. Also worth noting, just for purposes of clarity, and this is actually a point that to a certain extent gets obfuscated during some of the debates over the IP vaccine waiver that is currently being disputed before the WTO. Patents are on a country-by-country basis only. That is, a US patent is only enforceable in the United States, the French patent is only enforceable in France, and so on. The way I like teaching this to my students is that patents are like house cats. They are domestic creatures only, right? All right. Patents, that being said, they can be used as a governance instrument. They are not just an economic tool. There are ways in which choices about what gets patented and against whom a patent is enforced can be used to govern the development of the technology, make choices about what gets developed and who does the developing. Right. So first, on the first aspect, kind of what gets patented in the first instance, and therefore what is ultimately a property right and is subject to be excludable, right? Patents first need to be technically feasible. That is, the scientific landscape governs what technology is ultimately going to be excludable at the current time for the rest of the population. Patents are not otherwise awarded on science experiments or pieces of science fiction. And so to the extent that there are concerns about patents being used against future technologies, those are not necessarily readily in play for technology that is not, at least at the moment, technologically feasible. Patents can also be excluded, or at least people who hold patents can otherwise exclude others from using them on the basis of commercial consequence. That is, it costs money to enforce a patent against someone else. In the United States, for cases in controversy that merit $25 million or more, the median cost of attorney's fees is $7 million for each side, right? And so generally speaking, it doesn't pay to use patent enforcement as a governance tool unless there really is a commercial interest behind doing so. Patents can also be used as a governance strategy or as a competitive strategy. That is, that one can use patents as a government instrument to decide who is allowed to use a technology with respect to defining what the technological landscape is of commercial developers. And patents can also, or at least patent governance, can also be used in terms of determining what technology the patent office allows to be patented in the first instance. These are concerns related to subject matter, that is, whether or not inventions are truly natural products or whether they encompass abstract ideas, but also, at least with respect to the European Patent Office, concerns about moral utility. That is, are the patents themselves a technology that is ethically controversial enough that no one should otherwise own the technology? There's an asterisk here. I'll be discussing more about this in a second. Beyond this, there are also limits, or at least patent enforcement can be used as a limit, not just on what gets patented and what gets enforced, but against who can use the patented technologies, based on the rights of the patent holder. Right? A lot of the licensing restrictions that we otherwise see, some of them are baked into commercial versus non-commercial uses. That is, patent holders have otherwise granted the right to use a technology to non-commercial developers or academic laboratories, but not necessarily commercial developers without an affirmative royalties paying license. And there's other restrictions regarding who can use the patent technologies about whether or not they're being used as a research tool versus product development. That is, are you trying to develop genome editing technologies because you want to further the genome editing field, or because you want to create a particular saleable therapeutic product? In addition, developers use patents, or at least place restrictions on licensing patents, more on this in a moment, on their particular use. That is, it's not just who can use a technology, but the ways in which those individuals or those entities are otherwise using them. We could think of these as ethical restrictions. That is, you can use this patented genome editing technology, but only, for example, if you are not going to engage in tobacco research. This is an actual licensing restriction that the Broad Institute imposes on its patents. Or in some cases, you are allowed to use the technology in ways that you see fit, but you must report back to us the specific experiments that you are otherwise doing. Lastly, patents can be used as a government instrument simply on the basis of cost. That is, anyone and everyone can come in and use this particular technology if you pay the standard royalty fee, right? Cost to a certain extent is a barrier to frivolous or problematic uses, or uses by others who otherwise are going to be difficult to police. And the same is true here when it comes to patents covering human genome editing technologies. I said I would mention a little bit more about moral utility as a governance instrument here. It has long been the case in the European Patent Convention that there is an ordre public exception to what can otherwise be patented. Here in the United States, we refer to this as moral utility, right? The European Patent Convention, Article 53A, essentially states that patents will not be issued to certain ethically problematic technology. And this has been interpreted, at least relatively recently, as essentially banning patents on heritable human genome editing. That is, human genome editing of embryos, more specifically, right? The notion behind this is that because it's ethically problematic, and because to a certain extent, and I'll be discussing more of this later, it's anti-democratic in nature, no one individual or groups of individuals should otherwise own the specific immoral, quote unquote, technology. But the flip side of that is that because patents are a right to exclude as opposed to a right to use, this removes it from privatization. By removing the technology from privatization, it makes it tough to police. It lowers the barriers to anybody and everyone using it, not the opposite. I recently argued with Eli Adashi and Glenn Cohen in a piece in JAMA that to the extent that we're going to take moral utility seriously, or the notion that we're going to take ethically problematic technology seriously, one way, among many other ways, of policing their uses is in fact to privatize them. And so it may be the case that actually the ordre public exception in the European Patent Convention is doing more harm than good. It is allowing more research that people find ethically problematic rather than keeping it at bay. This essentially, to the extent that we have some regimes that allow patenting of this technology and not others, this shifts patenting to more permissive regimes. That is, researchers who may otherwise be interested in getting patents or doing research on this particular technology will simply move or do their research or collaborate with other researchers in areas in which this is allowed, namely the United States. Notably, there's no viable US analog to moral utility in the United States. It was long on its way out at the beginning of the 20th century, and I would say it died, died a violent death in the 1970s, after which it is almost the case that no other patents, or at least patent applications, were rejected solely on moral utility grounds. Gambling machines, weirdly enough, seem to be the last vestige of these. So I've spent a lot of time talking about patents and how they can be used, or at least on whom they operate as instruments of governance. I want to get a little bit more granular as to exactly what the mechanisms are under which this occurs. And namely, this occurs through licensing regimes. Another way of thinking about this is that you've got a patent on human genome editing technology. You want to use it to govern the development of the technology. How do you go about doing that? And the answer is through licensing. There's many different types of licensing regimes, many of which are actually public. And so to the extent that one is equating governance as with public governance, right, I think it's worth exploring some of the different types of regimes that are out there for public patent licensing in order to think about them as governance instruments. I'm going to start off by mentioning government licenses themselves. These are situations in which the government has the right to license a technology to others. Here in the United States, at the very least, this is predicated usually upon the government funding particular research that yields a patent. Under the Bayh-Dole Act we have here in the United States, research, even though it may be federally funded, otherwise allows its inventors to go off with permission from their institutions to go off and seek patents covering their particular technology, but the government otherwise retains some rights to the particular technology under which it funded. The ability to license a particular patents or technology to others can be thought of as a governance instrument in that it has the ability to expand the universe of people who have access to this particular technology over and above what the patent owner may or may not want, or to whom, over and above to whom the patent owner may or may not want to have licensed their technology out. In some cases, a number of cases, there are disagreements as to whether or not the government can out-license its technology to others, or other cases more specifically where the government does not originally have a right to license its technology to others and can force a private owner of a particular patent to license its technology to someone else. We refer to these situations where the government does not otherwise have a right in a particular technology and can license its technology to others, compulsory licenses. These exist in large part in the pharmaceutical context in a number of different countries, and there have been some famous cases of compulsory licensing with respect to pharmaceutical technologies in Latin America and in Thailand with respect to certain pharmaceutical products. Still, with respect to these compulsory licensing regimes, it is thought that these technologies, the title to which, the title of the patents to which, are still otherwise held by their developers. And this can be contrasted with another type of licensing regime known as Marchand rights, where the government, quote, marches in and actually takes the developer's right away to allow it to exclude others from using the particular technology. The government often is then required to license this technology to others. Like, this is not thought of as a government right to use, it's a government right to shift ownership from party A to party B. And so we can think of this too as a governance instrument to particular human genome editing technology. To the extent that we were worried that someone was going to lock up a particular technology or forbid it from being used in the human genome editing context, and to the extent that we thought that this may have some public health implications, Marchand rights, if they're statutorily available, would allow the government to step in and take that right away from one particular party and give it to somebody else. Beyond all this, right, there's also the government's rights to use the technology itself. That is, can the government's own laboratories use the technology for its particular purposes independent of licensing to others? These government use rights may be especially important in the human genome editing context when there is a closer tether between government research and artificial reproductive technologies. There is a very loose, if not completely absent, tether to that here in the United States. But in many situations where there is I was going to say socialized, the real answer, at least if anyone has experienced U.S. healthcare system, I would say sensible healthcare system elsewhere, there's a much closer tether to the government both using and policing the particular technologies there. And so we can imagine that government use rights to human heritable genome editing technology in those countries that do have this sensible government oversight healthcare system may otherwise be fruitful. There are also subject matter restrictions and like limits on what can be patented. I talked a little bit about this when we talked about moral utility, but one way of thinking about this is that to the extent that the government is making choices about what cannot be patented, that is bars against what it can't be patented, it's simultaneously making decisions about what cannot otherwise be licensed, right? And beyond all of these public concerns, there's also private governance as well. And these are some of the ethical licensing restrictions that I mentioned earlier. Ways in which these ethical licensing restrictions work and their deployment in the human genome editing context was a subject of a Nature Biotech piece for which I was a co-author. Christy Guarini, Baylor College of Medicine, was the first author here. That was published in 2017. A number of those ethical licensing restrictions include at least from the Broad Institute with respect to CRISPR-Cas9 technology, no research using tobacco, no using CRISPR-Cas9 technology on seed terminator technology, which largely has been fictitious and not deployed by Monsanto, but putting an ethical restriction on it that further prohibits companies from otherwise doing this. And then, of course, no heritable human genome editing technology as well. If these are the licensing regimes that we have, and if they are mainly public, or to the certain extent, if they are held by private entities who otherwise have a responsibility to make choices about them, these raise a number of democratic concerns, right? And this is the subject of a paper just published earlier this year with Naomi Schneiderman at the University of Pennsylvania Medical School, right? So one of the particular democratic concerns is that licensing power, at least in the private context, like it's pretty inequitably distributed, and it seems to be anti-democratic. It's inequitably distributed because it essentially accrues to the first developers of technology, which happen to be rich institutions, and it's anti-democratic because they essentially don't take their shots from the public, they take their shots from scientists, right? There are few real remedies to police this, right? There's few real remedies to take patents that currently exist and to spread them over a wider group of industry to allow them an opportunity to share their voices about what the appropriate role for governance in this, otherwise ethically complex technology is. And so to a certain extent, this inequitable distribution and this anti-democratic nature of ownership may, we could talk about this maybe during the Q&A, make the case for more robust either government use rights or in some cases margin rights if we feel that a particular developer is not licensing their technology wide enough, right? There also, frankly, should be said there's this risk of scientific elitism, right? Why should scientists who happen to get first across the post have the right to determine what the ethical restrictions on a given technology are? To a certain extent, this is scientific elitism. If you're a STS person, right, this is one of the things that may concern you, right? One of the things I just wanted to float out there just for you to think about is whether or not there is really any evidence that that scientific elitism is really ethically suboptimal, or to the extent you want to take a relative approach, whether it's really suboptimal relative to more democratic measures, right? There's a number of technologies here in the United States for which if the demos really had a say, it would be more, not less widely available and more ethically problematic, not less. Is scientific elitism in these circumstances really all that bad? Or do we think that scientists otherwise have a better pulse on what the ethically problematic uses are than plebiscite? Backwards, here we go. An additional democratic concern with some of these patent governance issues for human genome editing technology, right, is whether or not there are going to be conflicts over exactly who the public is in voicing their concerns about what the ethically problematic uses of human genome editing is with respect to patents, right? To a certain extent, one way of kind of assuaging those fears, right, is to think, well, people have the right to petition their representatives. I guess you would say in the United Kingdom, to write to your MP, right? But one of the things that we have found, at least here in the United States, especially when it comes to March-in rights, is that it seems like threats of March-in rights or threats of governance with respect to intellectual property because of public concerns seem to be just as good as actually doing something in law, at least when it comes to yielding votes. That is, politicians seem to get an equal amount of credit for quote unquote standing up to patent bullies as they are to actually doing anything about it. If that's true, we may be concerned that public tooth gnashing as voiced through the representatives may just be more smoke than actual fire. In addition, it's not entirely clear that to the extent that the public is concerned about ethical uses of the technology, that the public who is voicing those concerns is representative of the public as a whole. We can think of this as the greasy wheel syndrome, right? Essentially, it's the people who are speaking at the loudest volume that get to say that their opinion is the opinion shared by the rest of the public, even if that may not necessarily be true. In addition, we have a technology here that is technically complex, and even the legal instrumentation, as I've described before, is in of itself technically complex, and there's no real guarantee that the public's opinions about them necessarily align with either what is reality or what is otherwise feasible, right? This seems to suggest that some of the representative or democratic representative concerns with some of these technologies may not necessarily align with the way that we think they ought to align. Last, there's been some concern that using patents as a governance instrument, right, rebuffs democratic engagement, essentially walls off a lot of the decision making from more typical democratic venues, right? And some of the criticisms here I think are particularly salient. First of all, a lot of the stuff is post hoc, right? When we're talking about patents as a governance instrument, we're talking about patents after they have already been issued to someone, not necessarily either as a technology is getting researched or even as a technology is being applied for or prosecuted through the patent office. In addition, it yields this fiction of an artificially limited choice, right? Rather than asking ourselves more broadly, how should the technology be developed? What we're instead asking is, okay, who should these specific rights go to develop this particular aspect of the technology? If we're really doing this from nisi prius, there's no reason to think of why those choices should otherwise dictate how the technology would have been developed in the first instance, absent patents, right? Lastly, to the extent that we're mediating it through patents, we've kind of already hemmed ourselves in a little bit. We're like framing the narrative that, all right, well, we've got a particular technology, it's going to be owned by someone, patents are the instruments of doing that, who should the patents go to, right? Again, rather than thinking about whether or not there really are other types of public, legally enforceable governance instruments out there to guide the development of the particular technology. And on that score, I just want to mention that there's actually a bunch of other different ways of doing this. I realize I've spent my time talking about patents, but I don't want to suggest for a second that they're the only game in town, right? First of all, the FDA or the UK MHRA pre-market approval process is pretty significant and actually guides the development of a lot of therapeutic technologies. You're not, if you're a developer, going to plunk a bunch of money down to an ethically complex and not widely adopted technology if you're not going to get approval from the regulatory agency in the first instance. Beyond this, there's also private law, right? You've got torts. If you are harmed by a particular aspect of the technology, you can sue, at least here in the United States, but then also contracts as well, right? You can have the government, or for that matter, private party A and private party B engage in a contract to not develop the technology, even absent patents entirely. There's also funding agencies and review boards, right? In the United States, we have our National Institutes of Health, Wellcome Trust, in the United Kingdom, for example, and ICER or NICE. ICER is this private outfit here in the United States. It governs whether or not a particular therapeutic technology is cost effective, right? A lot of these decisions really are the tail that wagged the dog. They're the decisions in which people look toward as to whether they're going to develop a particular technology in the first instance. Again, patents or no patents. And last, and it really should be said, there's just raw politics, right? Patents, no patents, having politicians get up on the stump and thump their fist regarding whether or not a particular aspect of research should go forward and what the consequences will be if they do and why this is problematic, that cows a lot of developers out there, regardless of whether or not those claims are either legally enforceable, whether or not they dovetail with economic concerns, and importantly, whether or not there are the ability to get any patents out there to police anybody else from using that. All this is to say, don't diminish raw politics when it is present as a governance instrument. Right? This is a pretty wide and broad-ranging field, and so I just wanted to conclude with some of the outstanding questions that are out there, and maybe questions for you to consider during the question and answer period. Right? One of the questions that I have is what really is the relationship, if any, between dignity concerns, right? We shouldn't edit the genome because of human dignity concerns, and private law governance regimes. Generally speaking, dignity concerns and private law are pretty antipathic, right? We are assuming that despite an agreement between two parties, we should disallow some activity because it harms dignity interests, right? That being said, right, can these agreements somehow be harnessed for good? I think it's a question worth exploring more broadly beyond patents. I will leave that to the political scientists and government scholars, and for that matter, philosophers here on this call rather than myself. Another question I have is what is the empirical evidence that moral utility is quote unquote working? When the European Patent Convention gets re-ratified every now and then, right? What's the basis for it? What do we think is successful? Is it zero research in this particular area? Is it some but not all? Is it zero ownership? Is there a way to disentangle some of these questions from funding concerns? I think I've got a kind of cool empirical project to assess that, but nothing that I've even begun to tackle yet. Spent a lot of time talking about the United States and the United Kingdom and the European Patent Convention, right? But how salient is patent governance really globally? Is this really just a first world problem that really the barriers to the technology elsewhere really have nothing to do with patents and just more to do with access to healthcare technologies, generally speaking? I think it's a salient question worth asking, especially if you have more of a public health bent. Last, is private enforcement of ethical restrictions, is it really anti-democratic, or actually is private enforcement in some cases at the very least, a pro-democratic concern? I'm thinking about this a little bit more because I actually just got done reading a book about this by Sean Farhang, who's a professor at University of California, Berkeley. We actually have an oddly contrasting situation here in the United States for employment discrimination. You may or may not know, in the United States, virtually all employment discrimination cases and regulation are done through a private enforcement regime. That is, the discriminated individual sues their employer in court, just straight up private law. There's not an agency, there is, but their agency is relatively weak relative to this private enforcement regime that goes around suing employers to ensure that they otherwise comply with the law. And to a certain extent, this was a democratic design into the employment discrimination regime that we otherwise have. And strangely enough, it seems to actually work, right? So to the extent that you thought that these things were, polar opposites or they pulled against one another, there's at least one example in which they actually work pretty well in tandem. Is it possible they could work well in tandem elsewhere else? Okay. That is it. This is the end of my talk, and I'd be more than happy and delighted for the next 20 minutes to field your questions. So please.
Brilliant. Thank you, Jake. That was excellent. And I hope everyone will join me in showing their appreciation. I have actually for once managed to successfully find a little clap button, but I will clap as well because it's a small, slightly insignificant icon.
Sure.
So the first thing I just want to do is very briefly put the link to your paper with Naomi Scheinerman in the chat there. So I've just pasted that in. If anyone does want to go and look at that, it's open access. I recommend you have a look at it. Now, I I have a lot of questions, but I don't want to abuse my privilege as chair, so I'd like to see if anyone else has any questions. Could you raise your hand or indicate in the chat? I will try and spot that. Okay, people are still thinking, I think, about their questions. So
That's okay. I have this tendency to deliver presentations like, getting a drink of water from a fire hose. And so feel free to take a breather, stand up, walk around the room. But again, happy to field questions.
So I guess when you were talking through that, I was thinking a little bit about kind of Shobita Parthasarathy's work on patent politics, and her argument really is that the USPTO has been particularly resistant to the idea that there should be or could be any meaningful consideration of kind of societal or cultural implications of a patent within its remit. And one of their justifications has been that would create undue uncertainty for innovators, at least according to her interview research. The European Patent Office has been slightly more willing, but whether or not they've, how much they have realistically achieved in actually kind of doing that. I'm just wondering whether you think historically there have been other mechanisms in US law that have kind of dealt with some of those concerns that, that within the European Union or the European Patent Convention at least. And I know those are not the same thing, but the 98 Biotech Directive, as we know, kind of moved some of those order public concerns from European law into the European Patent Convention. Just how some of that maybe plays out, and possibly on whether you think is it a problem, or does the US actually have sufficient mechanisms, other mechanisms, to deal with any potential problems that arise?
Sure. So it's an underappreciated point, and I think this is one advantage. I don't want to pretend like it's an unalloyed good. It's not. But it's one advantage of being an actual patent practitioner. And I'll just note that the US Patent and Trademark Office, as a matter of law, lacks the legal capacity to craft its own policy. There's this famous case called Dickinson versus Sherkow about whether or not the United States Patent and Trademark Office has the capacity to adopt what we call here in administrative law land substantive rulemaking. USPTO does not have that. So even if the examiners, all whatever it is now, 10,000 examiners woke up tomorrow and they said, we really want to use the office as an instrument to police ethical technologies, they would instantaneously be legally prohibited from doing so, right? So it's not a matter of desire, it's not a matter of myopia, it's just simply a matter of legal capacity. Here in the United States, we have, for better or for ill, shifted all of these substantive patent questions to our Congress. Who has the authority and who only has the authority to make decisions about it. And in fact, if I could just add a little bit further here, Congress has, in some occasions, right, taken the chance to inject policy concerns into the patent statute, sometimes in ways that are, I'm really struggling to be generous here. Ways that are more political showmanship than reality. So for example, in I have to get my years right, 2014, Congress inserted a provision into Section 33 of the US patent statute saying that no patents shall issue that are directed to a modified human embryo or creating a human embryo, right? A straight up textual interpretation of that provision renders it meaningless. What does directed mean? What does modification mean? What if we modify cells prior to them being? And so the US Patent Office has, again, because they lack substantive rulemaking authority, just continued to issue patents related to this particular area of the technology because they otherwise like don't have the capacity to like sit down and engage in the philosophical exegesis about what directed to an embryo actually means, right? What about in Europe? Well, I mean, like this has come up in the human embryonic stem cell line cases with like some frequency, right? And so I think one of the things to think about as a research question is, all right, with the ban or the pseudo ban on patenting the lines themselves that are derived from human embryonic stem cells, what exactly has been accomplished, and what do we want, or what does a stakeholder in the European Patent Convention want exactly to be accomplished, and are we getting that? Right? I think to the extent that one believes that these subject matter concerns are best effectuated through moral utility prohibitions, I think it's worth just like getting a little more concrete about what the aim of those provisions are. I've obviously made my views clear, but I think it's maybe worth thinking about like exactly what their object was in the first instance, as to whether they're really accomplishing anything.
Yeah. So thank you for that. Yeah, I mean, I'm just looking. So if anyone has a question at all, you can just also turn your camera on, and then that will make you very visible.
Sure.
And you can ask the question in person, or you can type it if you would prefer.
I feel like I've also spoken at a pretty high level today. So, I mean, if people have questions about like more granular stuff, like what actually is going into some of these licenses or stuff, like, I mean, I'd love to sit and talk shop about that. I just didn't start off with that. I didn't know what the specific interest was.
So, Phoebe, do you have a question?
Yes, and thank you for the brilliant presentation. I teach patent law here in the university, and I actually follow some of your work previously on ethical licensing. And I think, yeah, we talk about patents and problems, but we couldn't really live without patent at the moment. And I understand that your critique on the elite governance, private regulation side of aspect. And I just wonder whether you have better proposals, because obviously now it seems that in like big tech monopoly as well, the IT big tech powers, they also take over all the democratic process, which is under very little scrutiny. And obviously this also replicate the same issue here in biotech. And I'm just wondering whether you have any proposal or any remedies on that.
Yeah, it's a tough question. I mean, I've just in general, and again, I don't want to pretend like this is an unalloyed good. Like I have a practical bent to this stuff, and so my usual response is like, it depends what you want, right? Do you want the technology to not be deployed in the clinic? The answer to that question is yeah. Or do you want to govern the technology in such a way that there's oversight over clinics using them? If that's the answer to your question, then I would just regulate clinics directly, right? Do you want the research to not be conducted in the first instance because one has moral qualms about conducting research over human embryos? Then you should design a regulatory regime that focuses on the research in the first instance. We do that to a certain extent, or most countries that have a large public R&D portfolio do that just by virtue of funding choices, right? So I mean, that's one way of doing that as well. Do you want the technology to be widely deployed, or for that matter, narrowly deployed in the public space? And then I would just regulate the deployment of the technology through regulatory authorities like MHRA, for example, right? Or even users or companies who are doing them. For reasons that I find to be unclear, it seems like there is an appetite to govern the technology with democratic input, And there seems to be less of an appetite in terms of crafting that into enforceable policy at the public agencies that have oversight over doing that. Don't exactly know why. And so that's just one of the reasons why I think a lot of this work on patent governance is just like, there are private governance regimes too. Like, and they're really simple. You don't need an entire parliament. You don't need an entire Congress to decide on what the appropriate commitment, right? I mean, that takes a long time, takes a lot of political capital, right? You can just have companies do this, right? And you know, that has downsides. We've seen that in the big tech space. It seems like there's just no appetite to police themselves, just kind of period. I don't know if I have hope, right? That would be wrong if I were to say that. We'll see what happens with the new Twitter CEO. I bring that up only because it's an N of one science experiment as to whether the problem of big tech regulation is really a Facebook problem or whether it really is a big tech problem, right? And so to a certain extent, if we're going to apply that in the human genome editing context, what we have, like, do we have a Intellia, Editas, CRISPR therapeutics problem? Or do we really have a human genome editing problem, right? Do we have a human genome editing assisted reproductive technology issue, or is it like one specific clinic that's doing this? I think it's worth thinking about what the scope of the problem is in terms of what we think the best mode of regulation is going to be, or at least the best mode of governance is, right? All right, I see we've got some questions in the chat. I'm happy to read them off. I don't know what the typical protocol is.
Yeah, I mean, normally, I guess in the interest of time, I think you sort of started to answer one of them. So there was a question there from Li Liu, which says, it seems like the premise of using the patents as an instrument to deal with ethical issues as it assumes that the aim of any research that we might find or someone might find ethically questionable is in itself to acquire patents. But what happens if it's not? So I guess to some extent that maybe covers things that are governed by trade secrets, or where there's not an intention to patent a piece of research, but there's still something potentially problematic about that. Do those things escape any patent law as a tool for governance then, or?
Yeah. I want to push back on the premise of the question just a little bit about that. The point is, like, the point of doing ethically problematic, like the aim, I should say, of doing ethically problematic research is to acquire patents. So if you take a look, for example, at some of the researchers who are really most invested in human genome editing, you look at Dietrich Egli, I'm sure I'm pronouncing his last name incorrectly, and Mila Topov at OHSU here in the United States, right? I think their aim is to get this technology to the clinic, right? As a funding tool, because their general counsels otherwise advise them to do so, they happen to be getting patents. Right. I think it is. I don't know. I'd be shocked actually if it was their aim. To that extent, right? Everything I said applies so long as researchers are seeking patents, whether it's their principal aim or not, or whether it's, their 10th concern on a laundry list of 11 concerns of their technology. Patents are, pretty enforceable legal instrument. They hold a lot of power. The ability to get injunctions, to tap people for royalties is pretty powerful, and in many cases is a lot more powerful than a lot of the soft governance regimes that we've otherwise seen floated. And so even if it's not the principal aim of researchers, I still think it's pretty important. It could still be a pretty significant cudgel, right? So I think it's still worth thinking about. Right?
Yeah. Thanks, Jake. So there are a couple of other questions here. Octavian, I noticed you posted several questions, but I'm not quite clear that they are how your question about discrimination relates to patents. I don't know if you want to clarify that at all, if you're still on the call. Yes, you are. So I'm going to move on to I'll release the last line from your slides. I cannot remember what the last line.
Yeah, no, sure. So one of the things that I mentioned, I think the last line of my slide related to the tension, if there is one, between democratic governance regimes and private legal enforcement. I think a lot of a lot, I don't know, a lot, maybe it's a lot. I don't know what constitutes a lot. Like a good chunk of the literature suggests that the two things are opposites, right? Like you have private law enforcement of a particular right that's pretty narrow. It could be anti-democratic. You could have people abuse it in various ways. But one of the lessons that we have seen here in the United States with respect to employment discrimination is that it can actually be harnessed for good, right? That essentially that foisting that in some cases, and there's this book about this actually, you know, here, the book is called The Litigation State by Sean Farhang, who is at Berkeley, UC Berkeley, right? Talks about essentially ways in which employment, like policing employment discrimination has been a private law governance regime here in the United States, you know, for decades and with some serious bite from the late 1980s, early 1990s, right? The reason I'm bringing that up, right, is to the extent that we want to begin to think about enforceable private governance regimes for human genome editing technology, maybe that's simply about creating a, you know, right to police some version of a tort, right, for conducting research or, you know, devolving this technology in the clinic, right, to individuals out there. I recognize, I'd be the first to recognize, like, that sounds kind of crazy. But like, I mean, that's how we've done employment discrimination here in the United States, right? And again, to some success. My only suggestion is to just not think of it so narrowly. Anyway, yeah. So we've got time for another question or two.
I mean, if you're happy to stay if you're happy to answer another question, certainly questions are there. So, you know, if we see it's just the two of us talking, Jake, then I will close.
No. Sure.
But I think you still got plenty of people.
Yeah, I think we've got a question from Paul Christopher about the relationship between patents and antitrust out there, right? Yeah. It is a great question. It occupies an entire body of literature in the United States about the relationship between patents and antitrust. Here in the United States, for a very, very, very long time, we have thought of patents as being a carved out exception to our antitrust laws, right? And super uncomfortable with connecting the two, right? We've got antitrust laws, they're robust, they're somewhat robust. And then patents are an exception to that. And so if you've got a patent, then you don't have to worry about antitrust laws, right? And there's a lot of nuance. Again, there's an entire body of literature about when and to what extent that this is true. But policing patents for, you know, policing patented products or services as being an antitrust concern is complex and is somewhat weak. Not so in Europe, right? Where there's just like a comfortable relationship about saying, we have two separate areas of law, and you know, just because they philosophically seem like they're antagonistic, it doesn't mean that they're enforceably antagonistic, right? And so things seem to be like much simpler there. I would imagine that to the extent that genome editing technology, once it gets approved in the clinic, if it really seems like it's in the hands of few companies, and if it really is being developed by only few licensors out there, that I have no doubt in my mind that the EU's antitrust authority will come calling. I have some serious doubts in my mind that the Department of Justice Antitrust Authority will come calling. And so we actually may see a situation in which this kind of anti-competitive policing may more widely kind of, I think for some reason I find this to be counterintuitive, may more widely distribute the technology in Europe than it otherwise would in the United States, right? And I say this is counterintuitive because I think there's more, I'm struggling to think of another example in which antitrust authority has been used to allow more competition in Europe for a technology that is ethically problematic. But figuring out, getting some better examples about those, I think would be a really interesting research project.
Brilliant, thank you. So I'm gonna, obviously if people have responses or further questions to Jake's answers, you can put them in the chat, or you can you can turn on your camera and wave and I will hopefully notice you. But I'm going to move on to a question from Liliana, who says, the question is the problem a problem for patents of global governance? So I guess, and the issue of kind of access to health for, at the global level for people in different countries, and I guess particularly in the developing world. And that maybe speaks more to some of the things you've thought about COVID and the TRIPS patent dispute rather than genome editing at the moment, because it's not really available to anyone yet.
Yeah, sure. Yeah. So on patent global governance for human genome editing technology, right? I mean, it really seems like it's to the extent that it's a problem, it really seems like it's a problem that's limited to mainly wealthy Western countries, right? Seems like basic access and cost of assisted reproductive technologies, which are the kind of base technology that you need to really start even engaging in editing in the first instance, really seems like that's the hang up in most of the developing world, right? I don't think really patents are either here nor there. And one of the things that I mentioned earlier, right, is like one of the governance instruments for patents is just the cost of enforcement. So it really costs a lot to enforce a patent. People aren't going to do it. And in a lot of countries, a lot of low to middle income countries out there, the legal bite of injunctions and enforcement is low, and cost is a serious concern. And even if there are patents on the books, and many times there are not, right, in those particular countries, no one really has the capacity to enforce them anyway, right? So is this really a problem that only exists in, I don't know, United States, other countries in North America, Europe, wealthier countries in East Asia? Like, yeah, probably. That still occupies, I think, a relatively large portion of users, or at least as of today, even if the denominator of total people who are interested in using the technology is otherwise larger. Right? In any event, well, look, Michael, thank you so much for having me. This was just wonderful. I can't tell you how delighted I am at the opportunity to present to you and your faculty and your students, and also to faculty and students from elsewhere, apparently. So thanks so much.
Thank you, Jake. That was a really interesting talk, and I think I think we can see from the discussion that people were interested, and hopefully they will keep the discussion going among themselves and in future papers. So thank you once again, and yeah, if everyone can just give Jake another clap, that was brilliant. Thank you.
Thank you so much, everyone. Speak to you all soon.
Bye.